everyone. It's a pleasure and a delight to be here with Upendra Baxi. The reason I'm here is because he's an academic and I'm not an academic. I have been in awe of him all my life, but today I decided that I'm going to come and talk to him and say it as it is. He has influenced me, he has influenced my thinking in ways that perhaps he will never know. We all know about the ways in which he has influenced the thinking of sitting judges. We've known about the ways in which he influenced his students, but he has influenced me, even if it means in the way in which I counter his arguments. And so today is a very special day for me, where I want this very one-to-one intimate discussion with Professor Baxi. And here it is. You have written very profusely on law, and you've had an extensive teaching career. I, on the other hand, have never considered myself to be an academic. I've been a litigator, and I have always wondered how you see this interaction between an academic and a litigator. What is the chemistry between the two?
I never thought about it, I've never the first time. But you don't believe everything you hear. I'm sure you don't. Otherwise you can't be such a good lawyer. So obviously, I have done some work here and there, and it's now many generations. And as generations go, you become a has-been, and a very nice state of affairs. It's a blissful, and unlike legal profession or litigators, who never retire. Academics retire in time. And they're not bothered by whether they're remembered or not remembered, by history or by coming generation. So it's a bit of fun life, right? And they never retire hurt.
Well, Upen, I have to stop you because I disagree with you. I'd like to know how many practicing lawyers you've mentored through your teaching.
That at one time, there was only one law faculty in Delhi. Now the situation has changed. There are national law schools, there are private law schools, public law schools. So everybody was a student. So we mentored a large number of people. Many of most of whom became judges of the High Court and Supreme Court. Many of them became lawyers and litigators. Many of them went to the bar and did virtually nothing. And some went to become law secretaries and so on, and government, members in parliament and so on. So we produced a large number of all of us, Latika Sarkar, and many others. We all produced a large number of students who served the Delhi legal profession very well.
Right. I am interested in knowing the relationship between academics and members of the judiciary. What is the means of communication between these two equally important constituencies? How do they communicate with each other? One obvious way is through their writings, but are there other means of communication?
Well, some of them know the students. We know our students first. Some of us know, not many at distance. There are two kinds of academics. One who sits on a very high pedestal and are not easily available, even if they do nothing. And others who mix and merge with students and become learners. In fact, teacher student, in my opinion, is a wrong conception. It already establishes a hierarchy. So, but it's not teaching, I say it's co-learning. We learn from each other. But there are those people who are co-learners and those who are teachers. Teachers are different kinds, species altogether. Co-learners, tend to know the would-be judges as to would be
Yes.
law.
When you in particular have had a close relationship with the judiciary, and correct me if I'm wrong, you've also been invited to be a member of the bench of the Supreme Court.
Yeah, I had lots of friends who were judges. Yes, you're right. And some of them I had the privilege of knowing personally, individually, and their families. And one of my regrets, while I remember it, I don't even remember many of my regrets. That's a regretful thing. But one of my regrets is I looked at, nobody has studied the difficulties that wives of the judges have. As you know, they come from many parts of India to Supreme Court. And some of them don't know Hindi. And some of them know only one language, that's their mother tongue, with Telugu or Tamil or whatever, or from the Northeast. And they've been terribly isolated because judge's wife, they are supposed to not to mix and merge with ordinary people, lest the judges might be, and so on, all kinds of notional impartiality. So I'd always wanted to, I knew judges' wives. In fact, some of them made very nice. One asked for me, some of them made custom for me. I mean, they knew that I like those things. So they, sign language, they said, wait for a while, we're doing something for you. And they knew what I fancied. Some prepared Sundays and all the feasts that I liked. They were very kind to me, I must say. And I was at a loss because I couldn't converse with them. And I thought I would do in my lifetime a study on judicial spouses. But I was never able to do that. I hawked this idea to some feminists. You were too busy to be burdened. I did some, they were less busy. And they said, very good idea, but they never did anything. So it was, yes, I had the privilege of knowing and working with some of the judges. We observed a rule of common decency that we would not talk about work. And we would not talk about, in fact, I remember meeting, he called me, Ajit Nasre. I'd just come to India, 73. And I think left in 77 or 76 or something, 77, I think. And I'd written a lot about him, and not very. Judges don't like, initially, they don't like criticism, and then they get used to it. In either case, they take it seriously. But they do occasionally read that. So it was early days of judicial accountability, and they didn't like criticism. And some of them still don't like criticism. But criticism is not meant as criticism. Criticism is meant for going forward, to retrospect what you've done with it. It's a means of accountability, democratic accountability of judges. It's very important to me. It is only when you have that accountability that you have political accountability you're worth talking about.
So what are the means of judicial accountability? I'm aware of some of them. One can bring cases to court. There have been 4 or 5 cases which have already been brought to court on the question of judicial accountability, if I may say so. One of them was initiated by me on the issues of corruption. I have initiated others on the issue of sexual harassment by sitting judges, but leave that aside. What are the other means of accountability? For example, which ones have you used?
Accountability in the sense I use during corruption, including those you spoken about. But I think of accountability in terms of communication.
Yes.
That is, what judges do should be available to ordinarily intelligent person.
But that's completely missing in the Indian context. That's my view. I would like to know how you deal with it, what you think about it.
Yeah, I do. I've suggested period. I've even committed the greatest crime one can commit. They need to repeat oneself. I've committed that crime. I repeated myself shamelessly and said, every judgment should be summarized by the bench that is giving it in one page. That should be executive summary. And it should be multilingual, available in every language, and should be treated as binding. That ensures judicial collectivity. Our Constitution does not, for example, allow for needless prolixity.
Yes.
In judgment writing. Our Constitution does not allow, if you read Article 145 of the Constitution of India carefully, there is no provision for separate concurring opinion. You can give a majority judgment or a dissent. There is no provision for separate concurring opinion.
Well, nowadays we see judges not signing their judgments.
That's the difference. That is not a, don't call it a judgment, Hindu. In Ayodhya case, five judges decided something, and one of the five gave a 109-page opinion. And my first sentence in my index article on Ayodhya judgment is that I'm a citizen of India, and I am not, by the Constitution of India, constrained to read an unsigned judgment. Constitution of India forbids an unsigned judgment, because unsigned judgment means there is no accountability. And Article 141 says the law declared by the Supreme Court shall be binding. When is law declared? Only when a judgment is signed, owned by the judge writing it. The judge himself or herself disowns a judgment by not signing it. How can we call a judgment? So I have not read 107 pages till today. I propose not to read it till my dying day, because that is not a judgment in the first place. So for my reading, Ayodhya is a judgment minus 107 pages. In case of the party, only once the Supreme Court issued a summary. But Mr. Sharma had a salvo, like somebody is not binding, somebody is not there in the common law, so what? Why can't we know it if something is not in the common law? It is more than I can understand. Why did we become free? Mr. M.K. Gandhi was asked by an English journalist, Bapuji, why do you want freedom? And you know what was the answer, which we have taken literally. He didn't mean it that way, but we took it literally. His answer was, I want freedom to commit my own sin.
Yes.
So, what is the sin in writing a summary? But the summary did not understand. Anyway, that was the only attempt to issue an authoritative summary, and it has worked. I've shown it in my writing that summary is useful. So there is one precedent, and I think we should issue that. We should stick with it. The present Chief Justice is very keen on judgments being reasonable, understood by everybody. And I think he probably should issue a statement if he is not. He issues too many statements, so I'm not up to date with the statements about bail, about extrajudicial statements. He should issue one. If he has not issued one, he should issue one before he retires on the question of summary. And summary should be judicially binding on all courts of then at 141. It should be the law, and it should be all constitutional languages.
Yes. Now, since you raised the question of Keshavananda Bharati, I'm fast-tracking to another question.
Yeah.
You have said that the Vishaka case must be read as feminizing the basic structure of the Constitution of India. Could you tell me what is your opinion on the track record of the Supreme Court of India on feminist issues?
Feminist issues, I can understand. Feminist issue is that of inclusion and equality. But that is an issue not only limited to women, it is disabled people, tribal people, indigenous people.
Yes, but your comment in particular, linking Vishaka to basic structure, is what was intriguing.
In that the feminist issue, feminist approach to life as inclusion should apply to many cases. But in Vishaka particularly, it was violence against women. that was thematized. It did not address all feminist issues. It only addressed sexual harassment in the workplace, and you reject a treatise on it. So you know better. So I think it was focused on a very specific issue, that is employer-employee relationship. And probably the retired Chief Justice of India was accused of harassment during post-retirement arbitration proceedings in one of the eastern states. I won't specify further. And that was by a young intern who complained that on the Christmas time in the evening, this gentleman harassed him. And he was very upset. It's Chief Justice. I don't know what ultimately happened. But yes, I know what happened. I wrote about it. It was held by Supreme Court that this does not apply, this law does not apply to internship. It is not an employer-employee relationship. Now, this is very strange to me. Wherever a judge or a former judge acts in dominant position against a woman and makes unwanted advances, it's a harassment. So why should their employment relationship? But if you say Visakha was limited initially to workplace, so there are difficulties there, the technical issues as to what constitutes harassment, what is a dominant position, etc. And I don't think they're beyond solution, but I think both the movement and the judicial forum are very slow in further developing Visakha. I don't know why, but that is the case.
I think I have an inkling why, but I tend to agree with you on the limitations of Visakha. Very few people have understood that it's a judgment which falls within the domain of employment law.
Yeah.
It was not projected as a judgment in the domain of employment law.
No.
In fact, the major tragedy of the judgment is it was Bhavri Devi's case which was the catalyst for this case, and Bhavri Devi till this day is awaiting a decision on her appeal in the court in Rajasthan. So my question then becomes, what is the value addition that these type of judgments make to the development of a feminist jurisprudence, or even to the development of movements? Because you can see the same thing happening today in a hospital context in Calcutta.
No, I think it could. As you no doubt know, constitutional common law grows out of analogy. The Visakha is a good start in some senses. The good complaint and my complaint is similar, is that it's not been extended. The implications have not been worked out jurisprudentially in all cases of violence against men, not merely harassment. Harassment is a form of violence. Now, I've been following it, and there are two judges, and there's a woman judge. And she's been writing insightfully on how this, in Bombay newspapers, how this should be extended. Visakha should be extended. And nobody has taken any notice of it. So I think it's great merit in going back to judges who have opined in the court and their superannuated writings. Given it a royal source as explaining the frontiers of the judgment, but it's not been followed up by anybody, because the lawyers think they are superannuated, judges think they are not 141 citizens anymore, and so on and so forth. So once you're retired, you're exiled. But I think a wrong thing. Many judges, for example, written on NJSC case, of course I've taken objection to it, and my dear distinguished colleague, friend, Korean Joseph, who took the view that NJSC was wrongly decided, and he was done the parties to hold that NJSC is wrong. And it retroactively dissociated from his judgment. I am against this retroactive dissent. But it's important to follow up what judges say about their own judgments after they return.
I can see that judges are violating their own code of ethics. And you have given one example that you deliver a particular judgment and out of court you criticize the same judgment that you delivered and say you disagree with it. It shows either intellectual dishonesty or it shows that when you were delivering the judgment, you didn't know what you were saying. But I can give you any number of examples where judges are violating their own code of ethics.
There is a judge's point of view. I've talked with some of them. And so why they retroactively, I call it retroactive dissent. Now, you're right, technically you can't dissent from your own judgment. My program wider. What about other judges who in good faith thought you were there? They were together. And what are the implications of overruling after retirement, so-called overruling, or expressing a different view? What happens to courage of conviction? That's one question. That people who are in the executive can ask of judges. If a bureaucrat changes his view, a parliamentarian, a prime minister changes his view, or act contrary to his view, or says he was wrong earlier, now he's right this time, or leader of opposition changes his view, now you've got one, and he might change, I don't know. I'm not concerned with X or Y. But the point is, if they do it, they are accountable. First, on the habeas corpus case after the emergence.
Yes, he did.
And he said he wished he had the courage to dissent, but they did not have it that time. So we applauded him when he gave his judgment, and we applauded him when he said he had not the courage to dissent. Then he gave another apology, and a third apology after the emergence. So that time, Mahesh Deshpande and Rani Deshpande used a magazine called Lex and Juris that started. And I wrote in that column, I wrote a column, something called lawyers existed, and violently protested at my not writing for them. I don't know what to do with the person who objected, but I did decide. But I did write for this journal regularly. So I said, look at Chief Justice, ex-Chief Justice Chandrachud. He has apologized 3 times. Now, if you look at pension is given for services rendered. If a person says, I committed a mistake once, it's all right. Just second time, third time, fourth time. Then I asked the question whether Mr. Chandrachud is entitled any more to a pension because he apologized 3 times.
Accountability.
You asked me earlier. He was very upset with me. I was in Bombay then. He and his wife, Prabha, were very upset with me. So I said, I'm not after anybody. I'm just raising a simple question. If I don't raise questions, the academic, who else will?
Well, that's the point. You hit the nail on the head. The role of the academic is to raise questions.
Raise questions. We are paid to that. We're paid to think. In a poor country, we are teachers in universities are paid to think, to talk, to research and write, and to something else.
Critique. Teach and critique.
Teach, research, read and write, and think and talk. That's what we are paid for. In a poor country, which modern labor does not earn our salary. And now the salaries are very high. In UGC's case, have improved. So if we don't do that, who will do it? Yeah, this is quite now what happens is that teacher's job is more effectively performed by people in media, people at the bar, people in the band. The trouble with India is that everybody is eager to do somebody else's job, forgetting his own job.
Well,
this is the problem.
Yes.
Every profession does some other professional job.
And you also now have judges who have public relations officers who invite the press along with cameramen into their homes, as we have recently seen. We'll come back to that in a minute. But my question to you is, to what extent, say, a bench of 5 judges or 7 judges or 9 judges has an opportunity to deliberate with each other before they write their individual judgments? You talked earlier about the collectivity of judicial decision-making. Should it not begin there?
Well, it shouldn't be there, but I've slightly reflected my own views. We have a huge problem against. And I think the breakdown of judiciary happened, conference system, after it was first court. I don't know any other court followed the conference system before I open. Judges do occasionally, particularly when they dissent, they send across the draft opinion.
They share.
But I don't know, without being inside, not being a judge, I don't know how this system, that, if you call that system operates. But I think it will add to the burdens and the time that judgments take to a full conference, like the American Supreme Court had. They have only 400 cases. They're complaining of overburdening. Judges of the Supreme Court had
I don't want to go down that road because it can raise...
hearing.
It raises many other issues. Do we need more judges? Do we have an...
There is no hope. There is no hope that there will be a conference system in India. Mr. Punchi, Justice Punchi, wrote the last word in the system in the third judge's case. He said he was given some opinion at 12 midnight. And next day they had to pronounce the judgment. They had no time to read it. And he the best opinion served by serving judge, who then became the Chief Justice of India and did nothing. So what they do as judges in the judgment, and when they have the opportunity to remedy things, then they're the chief, they don't do it.
Yes.
It's a very peculiar thing about Indian judges.
It's disheartening. We're looking at what we can characterize as a complete breakdown of the judiciary, especially at the Supreme Court level.
Breakdown, if you think it's very good for lawyers, it's a bonanza for lawyers.
But I'm not here in my capacity as a lawyer to talk to you. I'm here in my capacity as an ordinary citizen of India, concerned about what this institution is delivering to what Gandhiji called the last man. He said, when in doubt, what was his statement? When in doubt, look what you would do to the last man for the last man in this country. I'm here in that capacity. I'm not here in my capacity as a lawyer. For me, if the judiciary means anything, it means they have to deliver to that last human being, not just man, even woman. And I'm now coming to the question of Bhopal. In some countries, especially when you're dealing with mass torts, there is a provision for issuing a draft judgment, which is shared with the people who are before the court to give their inputs. Now, this technique has been used in the case of mass torts or in the case of, multinational liability, responsibility, and things like that. What do you think should be the way forward, given your involvement with the people who are arguing the case relating to the Bhopal Gas lease disaster? What is your opinion on the way that case turned out, and why?
Yeah, I did not know about the earlier part of the comment that there was a practice in mass torts in America. Not this effect. We don't go there, but I have quite independently thought about this, and I have said in each case, the common law says that lawyers' arguments are heard and reproduced by the judges, and on consideration of which only a judgment can be given. Unless the matters are so motive or something, there are exceptions. But so I think I'd suggested that every lawyer appearing the case should give a draft judgment to the Supreme Court. high courts, appended in the prayer, in which they can refer to as if they are writing a judgment. And the Supreme Court High Court can choose from the language formulation. Ultimately, they choose from the arguments which are learned, petitions are learned. Everybody is learned, by the way, and the court, which is very good. Presumption of civility, which is very good. But they're not learned in sense. Anyway, they don't want to learn from each other. That's the problem. If they learn from each other, they're very properly called learned. They're apart. So I think much of our problems will be solved by a well-written draft judgment by people who argue. Or maybe in certain matters, constitutional matters, they should be done. Essays should be submitted to the judges who can select. But that apart. In Bhopal, I think the American realists, the Jewish school, so-called, had an idea which they developed, which they did empirical work, which is known to most judges or lawyers, ought to be known, that judges decide the case at the first hearing, which way they are going to go. And then they let them argue all the time. They have decided already. So decision is not reason, but rationalization. It's a psychological thing, psychological thing. So judges rationalize what they've already decided. And they've decided very early by reading the brief or and so it's called the hunch theory of judging. So they have a hunch of what they will decide, they will listen to others. The mind is almost made up. So the mind was already made up in Bhopal to favor a particular petitioner, the Indian Budget Act. Why? Because human beings have all kinds of ideas, and like development, hazardous industry, liability of corporations, how far they go. Absolute liability, the government has victim side. Because multinationals have all the information about the case and all that. A product, the hazardous nature of the product. So we argue. So that was the draft was pungent and poignant and very good. Not just because we sat and did it. Academics were involved. But there were certain preconceptions about absolute liability. And only tort law, mass tort law. The absolute liability admission from defense. And somehow common law judgment is always that there is a defense and there is an attack. So adversary system consists, there can't be a lack of defense in adversary system. That's the idea of the common law. But it's an unusual tragedies, unusual happening. And so, cut it short, essentially, I think the mind was made up on absolute liability matter of principle. And secondly, mind was made up on the issue of settlement. Lest this case be heard by a garnishee or a small cause court in New York, and lest it be dismissed by that court, small causes court in New York, dismissing a Supreme Court of India judgment. The institutional concern. So mine was made up to settle, I think. And I've been on print in India Express and everywhere saying this in my number of parts. So this is a case to be studied in terms of a judgment always a preconception of the judge, or a judgment a common work of lawyers learning, exchange, dialogue between lawyers and court, or petitioners and court. Here the petitioners were excluded in the final settlement. We were not victims, we were not heard. We were parties to this too.
Well, Upen, I have to say this. I don't mind if it's not on the record, but this was one of my major differences with you at that point of time. I was totally opposed to the locus being given to the Union of India by a statute to fight this litigation. And if I'm not mistaken, I was the first and only one to challenge that law and to say, you've taken away from the victims the only thing that belongs to them, and that is their voice. Their voice. That's it. One doesn't mind losing after one's voice is heard, but the voice was taken away by that law. And in my opinion, that is what accounts for the judgment being what it is. But basically what you're saying is that once the settlement was signed, the game was up. And after that, everything else we did was like a post-mortem, trying to get the judgment reopened. As you know, the criminal case is not decided to this day. The criminal proceedings are still going on.
Still on.
So, I mean, for me, with my own involvement in this case, I do consider it to be one of the biggest failures.
It's a monumental tragedy, and there are two cases. One, as we know, ruled Shivkant Shukla by this direct descendant of Chandrachud, and the second is Bhopal. And this will should stay as reminders to the Supreme Court, where the error of its way, relax here, relax there, where lack of accountability can lead to catastrophe. Nothing else. Sheer mark-scale catastrophe, as in Shivkant Shukla, as in Bhopal.
Yes, well...
This is what they must remember. They should add to the oath should be amended to say, let there be no more Bhopal and Shivkant Shukla.
Upen, what is the worth and value of the oath of office that a judge takes on assumption of office? Is it honored in spirit, in letter? What is it all about?
Well, I think an oath of office can be a means of what Deepak Mishra said, Chief Justice Mishra talked about constitutional renaissance. Or oath of office could be a kiss of death to the idea of justice. Both. Because then if your duty is to deliver judgment according to law, administer justice according to law, then you can as well say goodbye to administration of justice. Because justice is not exhausted by application of law. It is always an application of law plus that makes justice. Whatever that plus is. So I think it's a strong word, but I think the oath certainly is talked about integrity of India, justice without fear and favor. I think we should make it more concrete in a way that remembers the things that have happened in India since the oath was adopted. And things that have happened in India, millions, but one can think of, in my mind, of Shivkant Shukla, that we should never give a judgment like Shivkant Shukla ever again. Doesn't require our Supreme Court happily to overrule it by extraordinary circumstance that happened. And secondly, Bhopal. That this thing should never happen. In genocide, the Jewish state and many others celebrate Holocaust happening. They say never again. Never again. And you must remember that never again. What is not to be done ever again. So the oath must be more specific. That you will not knowingly do injustice. Not that you will do justice. Injustice is patent. Don't justice without fear of favor. No, not knowingly do injustice on the face of situation which is unjust.
And that includes Bhopal. Because although our current Chief Justice has purportedly overruled the Shivkant Shukla judgment in one of his recent judgments, too little, too late, and no one has ever apologized for Bhopal.
No, but I think it overruled, but it's symbolic. With great respect, it's symbolic.
Well, everything in India happens symbolically.
Happening symbolic, constitution is symbolic. Symbolism is to be studied through semiotics. That's all. Symbolism to theatre, symbolism is not bad if it's summarized to action. Symbolism is problematic when it leads to quietism, to collaboration with injustice. It also requires symbols. Everywhere requires symbols. Language is symbolic. Everything is symbolic. So I'm not saying it's symbol. I'm against it. There's some good kind of symbolization and some bad kind of symbolization. Hitler was symbolized. You can tell if you say you can't say difference between wicked and good, then there is a problem there's a different kind of problem. But I think basically the oath should be a duty to avoid manifest and arbitrary injustice. That should be the oath, not to just do things without fear or favor.
All right. I am going to conclude by bringing you to the recent constitutional history of India, which is, pardon me for saying it, but it's the last 10 years. Cut-off date for me being May 2014, for whatever reason. There were conscious attempts. I've been reading a lot about this, and I have come to the conclusion that what is happening in this country is to set up a norm above the Constitution of India. And this is what they call cultural nationalism, or give it any name you like. But the attempt is to set up a norm above the norm that is the Constitution of India. How does one go about dealing with this? Do you agree with me or do you disagree?
I see ethno-nationalism as a problem everywhere in the world. Not that normalized the Indian situation, but you look around Europe, the first Nazi party was lawfully elected in one of the states in Germany, even has been told. So extreme right is taking giant steps, not baby steps, also the word. So is what is called legal authoritarianism or parliamentary majoritarianism. Think of a battle against for rule of law that EU is having with Poland and Hungary. If you just go beyond India, you will see the kernel of so-called liberalism. The world is changing decidedly for the worse, and it's true. But I think we should the answer lies with majoritarianism and legal authoritarianism in this beautiful concept of constitutionalism. I just wrote an article in Express on this. I sent it to you, in which I said it is capital. It's very good that all political parties in Parliament are kissing the Constitution. The symbolism, again, take your word, the symbolism of Constitution being supreme to all political parties. Are they not active? Everybody thinks symbolism is bad, it is trash. Yeah. I think de-symbolization of the Constitution means we kiss the Constitution, we put it on our head. We make song and dance about keeping the Constitution as it is, not changing it. And where have the activists all gone? Why don't they symbolize on the symbolism and do a greater song and dance and drama on the resilience of the constitutionalism at this time? I don't understand a mere negative critique of the state. I think positive, what is happening must be taken into account, whatever be the motives.
It is for politicians to answer that question. Neither you nor I are politicians.
No,
you're an academic and I am a litigating lawyer. But this brings me to what I saw yesterday and something that has disturbed me. I was almost cancelling this appointment with you today. I wanted to isolate myself and cry and wallow in my depression. But I resisted that temptation and I came to meet you. And that was video images of the Prime Minister visiting the residence of the Chief Justice of India. 3 of them, his wife and he and the Prime Minister sitting and praying to Ganpati on the eve of the Maharashtra elections. Now, for me, this is not acceptable for a person living under a secular constitution. You want to pray in the privacy of your home. No one is stopping you. I'm not.
Don't.
And on social media, I'm being told, here she is again, the Hindu hater. Okay? But it cannot stop my voice. I have to know what you have to say about this. A Chief Justice of India with his wife praying along with the Prime Minister in full public view.
No, I think religion has no place in public life. Religion is essentially a private, a personal matter, but one's own maker, or lack of religion, any belief. Article 25 guarantees religious freedom. But religion, Supreme Court itself said in my case, and my friend Justice Stephen Reddy summarized 6 points of mine, what we call to distinguish constitutional secularism from political secularism. And what is constitutional secularism? I've given 6 points, which are quoted. Stephen Reddy is quoted. In my case, he went even so far as to say no political party which is not secular is a constitutionally recognized party, and the law should be changed. We have not followed them. Mumbai was a long time ago. So anyway, the Supreme Court has spoken on what is constitutional secularism. One of the fundamental things about constitutional secularism is that state has no religion. Individuals and communities have religion. So from that point of view, it's a severe violation of a institution which proclaims 141 that the law declared by the Supreme Court is binding on all courts of India should follow the law it has declared. And as declared in my case, the state shall not have any religion. That's the first premise of constitutional secularism. Whether it is a first premise of political secularism or not, I don't know. But certainly it is. So how can a Chief Justice of India publicly violate 141? Is a question that he must now answer.
He must answer it. And be back to the fact that there's no commitment. Upen, finally, it's been a real pleasure talking to you, but I cannot resist the last question. I want to know what was the inspiration in your life for being the person you are. And thank you for being the person you are. But tell me, what was the inspiration for that?
Now you'll be tongue-tied for change. Although I'm very.
No, you have to answer that question. No escape.
I think about it.
No. It's a rapid-fire question, which you have to answer.
Okay. Well, I think the inspiration is and one word, suffering. My inspiration was, and always, my source of action came from the direct engagement with suffering of the people.
On that note, we bond with each other, okay? Whatever other differences we may have, we bond with each other on that, taking suffering seriously.
Yeah,
there you are.